We gathered early that morning, and we had different plans. We knew the routes that we were going to take. Now, we didn't know the outcome, but we were persistent, said, well, it does not matter. We're going to make a change, not only for us, but for the citizens in Columbia and our future generations.
The students who gathered at Zion Baptist Church on March 2nd, 1961, were really in the process of continuing a social protest that had been building up in Columbia throughout the early 1960s. Many of them had already been involved in marches through towns and communities. Many had been involved in sit-in movements at lunch counters and theaters and in bus stations. Many of them had already undergone nonviolent direct training by the NAACP, and yet they remained still quite dissatisfied. Even though Brown v. Board of Education occurred in 1954, they still saw the signs of injustice and discrimination everywhere.
We couldn't use facilities downtown. We didn't have any jobs available downtown. We didn't have what we knew and termed as equal rights in any aspect of downtown, in the downtown area, and the Columbia in general. But we said, this has to stop.
The students, in many ways, were the real thrust of this next phase of the civil rights movement. And so they come to Zion to really to offer a discussion about the attitudes of young people in the movement. And they saw the march on the State House as not simply an articulation of the NAACP, but particularly the articulation of young people and in their indictment with the failures of South Carolina to move toward equal justice and civil rights.
But we came together and we talked about it, we strategized, we talked about the peaceful demonstrations, and we talked about some of the other things. You know, at that particular time we had to walk downtown. The bus did not facilitate or could not facilitate us, so we just walked to the Zion Baptist Church.
They gather for what one of the students called a mini pep rally. They hear scripture, they hear prayers, they hear a real call to action. And then this group of nearly 300 or more are divided into cells, about 15, and they disperse from Zion, and they really go in multiple directions with the whole idea of converging on the State House grounds. And they all leave Zion. They go in multiple directions, and they travel several city blocks. The whole time they're being watched very closely by the local police, who were already informed about what is happening. They're already being watched by the South Carolina Law Enforcement Division, the state police, who sort of follow their pathway to the State House at the corner of Gervais and Main Street. And it is there where the students are confronted by a legal aid of the governor of the time, and are also confronted by the local city police, who make it very clear that they are only given a limited amount of time to be on the State House grounds, no more than 15 minutes. They're told they can make one sort of march through the grounds, and they're asked to leave.
They said, yeah, 15 minutes to disperse. We said no. Then they came, they had a policeman in the front and in the back and on the side, basically, and they made the arrest.
The lead student organizer of that march was an incredible young minister named Reverend David Carter. He had given instructions to the students about what to do and what not to do, how to dress, how to carry themselves. And so they went sort of going forward with a very clear idea that they would do nothing that would really merit arrest. They would not be unruly. They would not sort of challenge directly law enforcement. Instead, they would engage in freedom songs and religious songs. Ironically, they are arrested for their singing. They are arrested in some ways because one of the policemen argued on stand that they were boisterous and disturbing. And one of the songs they were singing was the Star Spangled Banner. Another song they were singing was We Shall Not Be Moved. And another song that becomes quite familiar in the movement, We Shall Overcome. And all of those songs are lifted up in testimony as signs that the students were engaged in unruly behavior. 187 are ultimately arrested and charged with a breach of peace. They are all carted off to the local jails, multiple jails in Colombia. Some who cannot fit into the transportation are literally marched through the streets from the State House to the jails. They are fortunate they have an incredible legal defense team led by Matthew J. Perry, Lincoln C. Jenkins, and a number of other lawyers from around South Carolina. The 187 was really a cross-section of youth activists from around the state. You had young people from the local colleges here in Columbia, Allen University and Benedict College. You had students from Charleston, from Greenville, from Camden, from high schools around the state, many of whom were well trained as youth activists in the NAACP. During the immediate days of the arrest, the Columbia NAACP team is in direct dialogue with the Attorney General, Robert Kennedy. They are in direct dialogue with Roy Wilkins, who is the head of the national NAACP. And so they're already crafting a very purposeful legal challenge. And in December of 1962, Attorney Jack Greenberg, who is a part of the national legal defense team of the NAACP, presents what is now the Edwards v. South Carolina case to the United States Supreme Court. In February, late February of 1963, the court rules on the convictions of the young people and argues that it was unconstitutional for the state of South Carolina to make criminal the public protest and public assembly of these young men and women. And it overturns the conviction in an 8-1 ruling in February of 1963. The Edwards ruling was significant because it was one of a number of cases, but a kind of milestone case that affirmed the right of protest in public spaces of young men and women who raised real challenges to what they deemed as injustice. And ironically, the ruling occurs in February of '63. At the same moment, you see some very famous organizing happening elsewhere in the country, most notably in Birmingham, Alabama, where months later, Reverend Martin Luther King Jr. And the Birmingham Project is unfolding. It is that period of time where he is in prison, where he pens the letter from the Birmingham jail, where young men and women are being hosed down by fire hoses. They are being arrested. They are being attacked by police dogs. And they are convicted for engaged sort of in public protest, violating city ordinances. A case moves forward that is finally resolved in the late 1960s called Shuttlesworth versus Birmingham. Those convictions of the young men and women in '63 are overturned, and one of the rulings that is cited as precedent for the overturning is Edwards v. South Carolina. And the Edwards case is cited in over 70 cases thereafter as grounds that permit the public protest and freedom of speech and assembly and redress among activists.
Every year, when the March on the Dome or some of the other marches come, we know that we're in legal right and legal standing that we can do this. And it's a direct parallel to our marching back there in '61. So I feel good, feel vindicated, and we got to keep on working.
I think it's important because we all recognize the extraordinary progress the nation and our own communities have made since the 1950s and 1960s. We are fully aware of steps that need to be taken to continue that progress. But I think when we study the history, we really begin to see the sacrifice of men and women who really dared to believe in a different America. And so I don't think they're fully aware of the phenomenal impact of what they did in March of 1961. It is only years later when that case is cited and when others reference it that you realize that what started at a church in Columbia goes to the United States Supreme Court, and it has extraordinary impact really all across the country. during the 1960s and 1970s.